Mr. Johnson, anything you'd like to say?
Your Honor, my client and I have seen and had a chance to review the recent investigation. Do you have anything to add to it or subtract from it? And we ask the court to proceed to sentence in this juncture.
Okay. Mr. Willis, have you had a chance to review the report?
I have, Your Honor.
Do you have any additions or corrections to it or anything that you'd like to say?
I have something I'd like to say, but I have nothing to add to that.
Okay. Go right ahead.
Pardon me?
Go right ahead. You said you had something you wanted to say. Go right ahead.
All right. Okay. I came here today with the intention to finally speak up and set the record straight. To free my homeboy Jimmy and to release pent-up frustration for what I see as a failure of our justice system. I've allowed the natural course of this process to unfold because I believe that this approach was virtuous. But last Thursday, after watching the unbalanced reporting of Fox News and how they allowed, without a shred of proof or decency, the degradation and humiliation of someone that is associated with this case to go unrefuted, I resolved first to put forth some mending amity. It is an axiom that the secret ways of people often produce peripheral mysteries that are as baffling as the ones in question. So I want to start by apologizing to the Bletch family for what has been mistakenly construed as a hateful act directed at them by me. My blown kiss that was spitefully garbled by the press as a rebuke to the family was in fact meant as a message to the prosecutor, D.J. Wilson. That message being that I'd figured out the truth and that he can kiss his future goodbye. Because of my failure to properly convey this sentiment, I've allowed animosity to flourish, and that needs to be remedied. To the Bletch family, I am truly sorry for this oversight. Back in 2015, your family demanded the Michigan State Police intervene in the investigation because you believed that the Muskegon Sheriff's Department was screwing up that inquiry. What you didn't realize at that time was how correctly you had assessed the damage that they had already done to your sister's legacy and any justice that she would receive. Early on, had I come forward and forced the press to do their self-professed fourth estate duty to report the truth and not allow them to so carelessly deliver the inaccurate facts of these cases to the public, much of this hatred could have been avoided. So today I stand before Nicole Windbag, families, and my community to proclaim the realities of these cases and set the record straight. The two most important days in a man's life are the day he is born and the day he finds out why. These words, spoken by Mark Twain, always resonated with me, but until October 26, 2017, I never truly understood their meaning. On that day, the course of my life would turn. 5 people, Lieutenant Jeffrey Crump, Detective Lisa Ferreras, Detective Lieutenant Michael Kasher, Captain James Christensen, and Muskegon County Prosecutor Dale J. Yeltsin, sat before me, each refusing to meet my eyes, while the anxious Lieutenant Crump took a note to tell the truth, the whole truth, and nothing but the truth. These 4 veteran police officers, including Jim Christensen, whom I grew up with in Cloverville, knew that the state's ballistics expert was about to perjure himself at the behest of Prosecutor Hilson. The spineless DJ, who to this day still hasn't looked me in the eye, was aware at that time that Bullet 17 was mistakenly taken from a Muskegon Police Department's evidence locker, MUPD number 45018, by Brian Harris, and not just erroneously written 4 different times by 3 different people at the Michigan State Police Crime Lab as MCSD number 45018 back in 2014 for the reports GR 14-3508 record number 3, or yet again for the new report in 2016 record number 25. He knew that bullet, which was the only one remotely matched to my gun in 2016, was not taken from the body of Rebekah Bletch, nor did it match the 2 that actually did. The Supreme Court, in its ruling for Mooney v. Holohan, wrote of this type of miscarriage of justice in 1935. The court stated, "It is a requirement that cannot be deemed to be satisfied by mere notice and hearing if a state has contrived a conviction through the pretense of a trial, which in truth is but used as a means of depriving a defendant of liberty through a deliberate deception of court and jury by presentation of testimony known perjured. Such a contrivance by a state to procure the conviction and imprisonment of a defendant is as inconsistent with the rudimentary demands of justice as is the obtaining of a like result by intimidation. I am innocent. I stand before you today proof that the promise of Gideon is dead. Not only did the justice system for indigent defense fail here, but the promise of equal protection and due process as well. Our system of government relies on many principles. Two of these are a belief that everyone deserves justice equally and that money shouldn't be part of that equation, but also a fair and balanced approach to that justice is consistent with the fundamental principles of liberty which lie at the base of all of our civil and political institutions. Not only did the public defender fail in this regard, but more poignantly, the jury, press, and the state's prosecuting attorney, E.J. Hilson, did so as well. My defense was hampered from both sides of the adversary system. First, by the state in denying me crucial chain of custody discovery items, and also in its destruction of key pieces of evidence for the Bletch case, but also from my attorneys, who regularly denied me access to important information I needed to make quality decisions, and its ineptness at laying out a case that could be articulated to a disenfranchised jury and a bloodthirsty public. Along with these 5 jurors who couldn't even stay awake long enough to listen, Janet Broadbent, Tricia Simpson, Ron Felon, Marquise Grayson Thompson, and Patricia Musgrove, the other members of my juries took no stock in their duty to hold me innocent until proven guilty. They were more concerned with placing the blame and seeing the salacious evidence that was put before them by unscrupulous news organizations and a prosecutor willing to put perjured testimony into record than they were for the truth-seeking which they all had sworn an oath to do. This can be demonstrated further by the fact that one of my jurors, Sarah Andritis, was caught Facebooking about the proceedings during the Bletch trial. To another one of the Bletch jurors, Michelle Hansen, who was sitting in the front row at the Heeringa trial with the Bletch family, chatting like they were old pals. Clearly to all these members, these trials were just an exercise in feudalistic justice. Catch them, flog them, imprison them. The disillusionment with the ideals of American values played a big part in what happened here in this courtroom. Between TV8's clueless Heather Walker screaming for her soundbite of panties, handcuffs, and dildos, to the so-called jury deliberations that were purported to have occurred, this was all just another humdrum day in the psyche of Americana. It has been said, we assign a moment to decision to dignify the process as a timely result of rational and conscious thought. But decisions are made of needing feelings. They are more often a lump than a sum. People rarely think anymore, and it showed here with this jury. The evidence showed that the eyewitness, Susan Follett, when asked, didn't recognize me as the driver of the van, and she testified she remembers every face that comes into the store. Both her and her ex-husband, Eric Barber, agreed that the light in the back of the store was off when the van left. But both Craig Harpster, the first citizen on the scene, and Corporal Hoaxema, the first officer to arrive, both testified that this light that can only be turned on from inside the Exxon station was on when they arrived. In that few minutes of time between the van leaving and Harpster's arrival, someone else had to have turned this light back on. The maxim, Occam's razor, which states, in explaining something, no more assumptions should be made than what is necessary, comes to mind here. The fact that one of Jessica's many lovers, Jess Ammerman, who was caught scoping around the station by the North Shores Police Department's Detective Casher that night, around that same time, was discounted as well. It seems blatantly obvious to me that this town and country van the police so adamantly searched for had absolutely nothing to do with Miss Heeringa's disappearance, and was all just a prosecutorial red herring. I too fell into this group of fantasy thinkers, believing the police could be trusted with not fucking up an investigation. I refuse to believe my best friend in the world, a North Shores policeman, who would frequently talk about how others in his profession would bend the rules, lie in their reports and while under oath, and back each other up in that old boys network, Brothers in Brown, if things got tight. I've also been to many parties with him where I heard firsthand from many of these same cops who threw perps off the roof and then fabricated in his report that he had jumped, to several others who boasted about certain pieces of evidence mysteriously disappearing just before court. It's no coincidence that Brian Harris, who was in charge of the evidence locker for the Sheriff's Department back in 2014 when the original MUPD ballistics mix-up occurred, is now in charge of the North Shores Police Department's evidence lockers after the fix. Old boys network indeed. It took a scared, drug-addicted teenager with a juvenile record, whom I only tried to help, cure me of this illusion. I found out the hard way, unlike the very culpable Madison Nygaard, whose juvenile records were sealed and couldn't be used for court, that once you're deemed a convict, the burden shifts to you to prove your innocence. There's a reason Muskegon County has one of the highest conviction rates in the state. The Constitution of the United States has in its preamble, "We, the people, in order to form a more perfect union, establish justice." This promise, made over 225 years ago, remains unkept for those of us who cannot afford proper representation or access to the same resources that the state has when it comes to evidence gathering, laboratory, or investigative personnel. The Sixth Amendment of that same document was put in place by men who deeply love their freedom, but who knew that government can't be trusted to just a few. When only one voice is heard, the very freedoms being sought are lost. These words, I paraphrase from an anti-federalist letter, imbue what was so very important and imparted in our Bill of Rights. Due process is at the very heart of our jurisprudence. If a person is denied this, as I was, through deliberate deceptions, purposeful manipulations of the theft of my attorney's notes and discussions, or the court's failure to render a proper decision after my third assigned public defender, Brian Hostica, turned turncoat for money to the prosecutor's office, then shared that very same attorney-client ballistics information to the state's Lieutenant Jeffrey Crump his first week on the job in August of 2017, so that Crump could alter his ballistics report number 25 on August 25th of 2017, just in time for court. How is a citizen to get a fair trial, let alone advice that he can trust? My grandmother, Leola Agneta, sacrificed her well-being to forge a better America. My grandfather, Lawrence Wesley, fought to protect my presumption of innocence. Both believed, as my parents, Pamela and Lawrence, did, that all people are equal under the law and deserve this right. In Gideon v. Wainwright, the Supreme Court expounded, the right to counsel may not be fundamental and essential to fair trials in some countries, but it is in ours. I believe in Jesus Christ, and because of that, I can say this. Due to a lack of funding, a careless disregard for truth-seeking, the desire to reach a rash and inattentive conclusion to an unproven crime, or just plain falsifying evidence, not only has this promise been murdered, but also left to rot at the feet of a weeping Lady Justice.
Judge, just real brief. I first and foremost want to thank the Muskegon County community for their support during both these cases, in particular this last trial that we went through. It goes without saying that this community is blessed with some very dedicated and tirelessly working law enforcement officials, including the gentleman sitting to my left. In all these matters, there are a lot of hours, weekends, time off being used to investigate these matters to its fullest. This community owes our law enforcement community a great deal of gratitude for all that hard work, and quite frankly, They did all the heavy lifting, and I just had to present it. First, in the other individuals that I'd like to thank for their support certainly is the Bletch family, including the two sisters who provided a lot of guidance and support through all this, as well as Madison and their mom, Carrie. They certainly played a very huge role in this case, and I appreciate their support as well. Quite honestly, Judge, in my career, and I've been doing this now almost 19 years, this man is probably one of the most dangerous men that I hope to ever encounter in my career. He shows no remorse, no lack, no ounce of dignity or integrity. And it's clear that the justice system has the right place for him, and that's behind bars for the rest of his natural life. And I know that my comments are kind of, it doesn't really matter, of course, in a sense, how the court's going to sense because that's what the law requires, but certainly I think his display throughout these cases, and certainly his display this morning, goes to show that we have successfully locked up an individual who, had he not been caught and captured, would have continued his killing in this particular community. So with that, Judge, I'm going to sleep very well tonight, knowing that Mr. Willis will never see the light of day again. Thank you.
Well, as the attorneys are aware, I have several cases pending involving this particular defendant, so I don't intend to comment at this time. I don't think it'd be appropriate. Also, the court is aware that there may be post-conviction motions in this matter, and I'm not going to do anything to create any possibility of the court being disqualified from further litigating these cases, so I'll refrain from comment. It's the sentence of the court at this time on count 1 that you serve a term in the Michigan Department of Corrections of not less than 18 years, 9 months, or more than 40 years with credit for 636 days. On the charge of felony murder, it's the sentence of the court that you serve a term of life in prison without parole. There will be a $68 state cost fee on each count and a $130 victim fee. These terms are served concurrently with each other and concurrent with any term you're presently serving. You have a right to appeal your conviction and sentence. If you're financially unable to retain an attorney, you may request the appointment of one on a form. You're being provided with this time within 42 days. Paul Peterson. Is he in jail?